out of that experience. I hope that my talk is relevant to you, but I would request that, wherever you find a gap, kindly ask questions. I will try my best to answer them. I'm very sure that, these students of B planning will contribute towards the better planning of urban areas, because this is the biggest problem nowadays. We are urbanizing very fast, but either there is no planning or there is poor planning. So, and then land administration or land records, they also play a role in planning. So I hope that everything is relevant to you. Please, second slide. So I just, in my effort to be relevant to you, then I just looked at your syllabus, and I have been told that Unit 5 says that land assembly and administration. So models of land assembly, national and international cases, bulk acquisition, land reconstitution, I am not dealing with specifically, but the second part of this, land administration, methods of land records in rural and urban areas, organizations responsible for land records and land assembly, examples from different parts of the country. So probably I will be able to cover this topic, and then land assembly is very much related to this. You can ask any questions on that topic if you feel. Next slide, please. So my lecture will be divided in 4 parts. One is land records or record of rights in rural and urban areas. Then registration of land transactions, land information system, that is mainly computerization. It's I will cover very sort of briefly this, and then problems and possible solutions with our existing system of keeping records and registering the land transactions. These land records and land record of rights and registration of land transactions, these are basically almost two subsystems working almost independently in India. Registration of land transaction is done under the Land Registration Act, which is a central act, and land records and record of rights are maintained by the district authorities under the state acts. Unfortunately, they don't share a lot of synergy between them, and that is one cause of a lot of confusion in this field. So I will deal them separately, and also tell you where are the problems and what are the connections between the two of them. So next slide, please. So what is land administration? I'm not aware whether there is any textbook definition of land administration, but this is made of 2 parts, land and administration. So whenever we talk of administration, it means of involvement of the government or government supported institutions. So what I feel is that whatever involves interaction of land, people and government or government institutions, that will form land administration. So if we go by this definition, then we can say that institutions, laws, procedures, policies and processes related to land ownership and other rights in the land, taxation relating to land, taxation mostly you see that property tax or stamp duty on land transactions, or there can be other kind of tax also, site tax or some taxation on planning permission, etc. Land use planning, control on use of land, which is basically mostly the job of the municipal committees and planning departments. And fourth is land development, construction over land. When there is construction over land, whether it is individual construction or some builder does it, then also certain regulations, policies, laws are involved. So all these, I think, can be called collectively land administration. So next slide, please. So these concepts, when we come on specific, in Indian context, probably these functions will include land administration, record of rights, which I have told you that it is maintained by the district authorities. I will discuss in detail later. registration of land transaction, which is basically done under the Central Act, Registration Act, and then land information system, which is also related to these two things, but it can be dealt separately. That information of the system about the rights in land, which is available to the public as well as to the government. And then the property tax, planning regulation, permissions, regulation on construction, regulation on builders, etc. So in my talk today, I will include first three parts: record of rights, registration of land transactions, land information system. Rest of the things I will not be covering in this talk today. Next, please. Before going further on this, I would like to tell you that these are the terms which are normally used in context of land and property. Land, property, immovable property, real property, estate, real estate. So these terms you might have heard, and let me tell you, at least in Indian context, they are almost interchangeable. There is not much of difference in these as far as law is concerned. In law regarding record of rights, where the land records are maintained in urban and rural areas, mostly word land has been used because mostly they deal with agricultural land with not much of construction over it. So then mostly word land is used. While in our Registration Act, word immovable property has been used. So immovable property means that land plus any construction over it or anything permanently attached to it. And the other words, property, real property is mostly used in the USA, which means the same thing. Estate and real estate words are mostly British terms. They call some right in the land, they call it estate, and then real estate is almost the same thing. So in Indian context, these terms are almost interchangeable. So whenever I talk of say land, that means it includes property, it includes building, etc. Next, please. Now there is another concept of ownership and rights in land. Why we are discussing this separately? Because rights and ownership in land is slightly different from other assets. Say rights in land or ownership in land is very much different from say a TV or an item of jewelry. Once you own a TV, then once you bring it to your home, there is no possibility of interference of your possession by anyone. If you have a jewelry, then you are a sole owner. You can do whatever you want, and no one is going to, unless a thief comes, and no one is going to interfere with your possession. But in case of land, it is different. Land is lying in the open, so it is lying in the open for interference by whole of the world. Someone might be walking over it. Someone may utilize its groundwater. Someone may, the government may like to lay a pipe below it. Government may take an electricity line over it. So there can be interference from many people in your land because you cannot carry land with you always. You cannot put it in a locker. So therefore, rights in the land should be known to everyone. So that's why right in the land we call them jus in rem. This is a Latin term which means right against the whole world. When we purchase a TV from someone, then there is a contract between the two parties, and it is called jus in personam. That means I have obligation to pay him money, and then he will give me TV, and the deal is over. But when we acquire land, then we acquire right against the whole world, because anyone can interfere with my possession, anyone can interfere with my right. So everyone should know that I own this land. So therefore, Therefore, there is a need that whenever I buy a land, whenever I own a land, the whole world should know about it. Whole world means that people who are interested, third parties, maybe people of that village, maybe people of that city, or your neighbors, etc. So that's why there is a need for recording land rights in a public record, because everyone should know about it. So that is one aspect of rights in land, that it is just in RAM. Second aspect is that I don't know what do you understand when you own something. It's a legal concept. Suppose we own a TV, then we can do whatever we want with this with this TV. Maybe that we can break it, we can throw it away, we can use it probably as a box, we can use probably it as a table also. It is my sweet will. When I own a piece of jewelry, I can melt it, I can convert it into a gold, I can just destroy it also probably, I can display it somewhere, I can wear in hand, I can wear in my neck. But with land, so much liberty is not there. Suppose you own a land, you may not be owning minerals below it. You may not be allowed to mine that land. Suppose you are owning a land, but you may not be allowed to raise a 100-storied building on it. You are owning a flat, but you can't make alteration to it. So once we say ownership, ownership is a basically bundle of rights. You may have majority of rights, but still it is a bundle of rights. So your rights are always limited on a piece of land or property as per the existing law. So whenever we own the land, we always own limited rights on it, a bundle of rights. A right of so-called owner may be more than a tenant, but still his rights are also limited. So we own only a bundle of rights in land. Second thing is that whatever rights we have, those are enforceable against whole of the world. So these are the two concepts which are different from owning a movable property. Next, please. So now we start with our first part, that is record of rights. Next, please. Record of rights, this concept was introduced by British about 150 years back. And let me tell you, this unfortunate that in last 150 years, not much change has taken place in the law. At that time, main purpose of the record of right was collection of land revenue. So that's why sometimes it is called physical record also. And because in 1841, about 60% of the revenue of the government came from the land revenue. That's why Britishers were so much interested in land revenue and maintaining the records. That was the sole incentive. But in 1980, it was only 2%, and today it may be even less. So let us understand that originally these records were created for collection of land revenue, but now it is not so. So law might not have changed, but purpose of these records is maintaining the ownership record for the benefit of the people as well as for the benefit of the government. So normally the law and procedure should also have changed with the change of orientation, which unfortunately has not happened. Then it is the most comprehensive or only record, parcel-wise record available in India, where against each parcel of land, rights of the people, owners or tenants, etc., they are recorded. The planning students might have come across the term cadastre. So basically it is equivalent to cadastre maintained in many European countries like France, Netherlands, etc. This is the practice of continental Europe only. In UK and America, cadastres are not maintained, but this is almost equivalent to cadastre. Though in India, we don't use this word so often. Basically, it is cadastre, but it is more than a cadastre in France or Netherlands because it is a legal cadastre. It has some legal validity also. I will, in the next slide, I will tell you this thing. Next slide, please. So this is called, I told you, record of rights in record. So it is now it is maintained under the laws of the respective states. So these are the state laws which were introduced by the Britishers, but these are different for different states, but almost they are on the same pattern. I will just list out the laws also in the next slide. These are available, these are applicable for the cities as well as for other urban areas. Many people have impression that record of rights are maintained or are to be maintained only in the rural area. That is not true. All the acts of the state governments, they cover urban area also. That is a different matter, that because of difficulty in maintaining urban areas, because of the typical administration of the urban areas, the records are not being updated or their maintenance has just been abandoned. But that is a aberration, but not a law. So these record of rights are supposed to be maintained as urban areas, for urban areas as well as for rural areas. These records are maintained by a sort of a battery of officers, right from financial commissioner, divisional commissioner, collector, tehsildar, patwari. They are all called revenue officers, and mostly department responsible for maintaining these records is called revenue department or revenue and settlement department or revenue survey department. Those departments in the states, nomenclature may be different in different states. So they are basically responsible for maintaining these records. A very important legal concept is that presumption of truth is attached to the entries in the record of rights. I would discuss it further, this concept, but that gives legality to this record. As I told you that mostly cadastre in continental Europe, they are basically made by the surveyor, concerned with survey only, that cadastral map, etc. They might not be having a legal validity. But in India, it has a legal validity because law says that if something is written on this regard, it will be presumed to be true unless proved otherwise. So unless there is a legal case, unless there is a legal order to the contrary, whatever is written in the record will be assumed to be true by the stakeholders. Next, please. So I mentioned about the cadastre. So this is the internationally accepted definition of cadastre, which is given by International Federation of Surveyors. So you see the main points, that it is parcel based. It is a record of interest in the land. Then geometric description of land parcels. So map is there. Then value of the land parcel, it may be there, it may be in our cadastre, it is not there. And it can be used for legal purposes, management of land and land use. So as I have told, and for physical purpose, that is collection of land revenue. So I have told you that in India, it is used for physical purpose, which is not very important now, and mostly for the legal purpose. Next, please. As I told you that this record of rights is maintained under some specific state laws. So I just listed laws of some few states for your information only. I have list in third column it is existing law, and in fourth column predecessor law. Predecessor law just mentioned so that you know that when actually it was introduced. So these and the successor laws are almost not much of change. Some just change of area or jurisdiction, etc. Because of this reorganization of the states, some acts had to be changed. So you can see these things that this list you can go through. But as I have told you, that's almost on the same pattern. Almost on the same pattern. Next slide. Next slide. Yes, and then yes. So in the record of rights, many documents and many registers are maintained, but the most important registers are these three. Register of ownership, which mostly records possession, area, category of land, and land revenue applicable on that. Then the mutation register. This is to record the changes in the record of rights whenever there is a change of ownership or any other change. Then a cadastral map with a distinct number assigned to each piece of land. As I told you that it is the only comprehensive parcel wise record. So the parcels are shown on this cadastral map, and field book, which gives the details of the measurement, how the area has been calculated. So just you can understand these records because many people might not have seen these records. So I am showing you a sample record. I have taken this from Himachal Pradesh Jamabandi. In Himachal Pradesh, Punjab and Haryana, it is called Jamabandi. So next record, please. Next slide. So this is a cadastral map. So in cadastral map, all the plot numbers are shown, and we will focus on this plot number I have circled 3444 oblique something. So all these plot numbers belong to a government or some person, and these numbers are given on this map, and corresponding to this number, the details of ownership and will be appearing in the register of ownership. So next, please. This is the field book. You can zoom your screen if it's not visible, but in this field book actually all the measurements are shown, because how the area has been calculated, so it just gives the details. Otherwise you can measure on the cadastral map also, because it is to the scale, but sometimes may not be very accurate. So this is also an important record. In case of any dispute, this field book is referred, so how the area has been calculated. Next. This is Jamabandi. So basically records of ownership. This is register of ownership. You can see that in third column, this is the owner is recorded, some Surinder Kumar something, and then if there is a possession of someone else, some tenant, then he will be recorded in fourth column. Here it is Kabja Swayam, that means it is under his own possession. Then number khasra, which was mentioned in the cadastral map, it is mentioned here. So this is the record, ownership record of that khasra, plot number. And then there are other this land revenue, etc. Next. Next.
Yeah. Sir, I just request you to go back to the previous slide, and I'll request Siddesh to zoom in a bit, because we couldn't see it very clearly. Can you zoom it a little, Siddesh?
This field book, when ma'am? 16th slide? Zoom it, let us see.
Next one, please.
Next one. Yeah.
Zoom. So you see that in third column, this is second column is basically serial number of this khata, that is ledger account, and then in third column is mentioned Surinder Kumar Putra Shrimati Shakuntala Devi Putri Rama Sthaniya Vasi, means it is local resident. Then in fourth column, Kabja Swayam means that it is under his own possession, there is no tenant on this. And then in fifth column they write some means of irrigation, so Apashi means irrigation. Then in sixth column the plot number is mentioned, which has reference to the cadastral map. So here the 3444 by something, which I have shown you in the map. And then here in the seventh column, this area is mentioned. This 293, I think it must be some square, acre or something. And Jai Safed is the basically category of land, way of classifying the agricultural land. So the kafiyat is remark. If any remark is there, it will be written here. I will show you that when they have a remark. So this is the anything on this, please.
Sir, are these? There is a question from a student. Are these records or maps digitized and stored?
No, this is yes. This is actually I would have been telling you on the computerization. This in situation, every state is trying for computerization. Progress is different in different states. So some states like Haryana, Himachal Pradesh, Karnataka, they almost 100% they have computerized, and you can see on the internet. Even Delhi record is also available. And then some states are still doing it. So, but everyone is working towards it. and I would in detail I will tell you in my third part. Okay. So this is the copy of that only. This is the mutation rate. Next please, mutation rate. No, no. Before that, yes. This is the next mutation rate. So you can zoom it also because it is manual. You can zoom it little. So what has happened? This Surinder Kumar has sold his land to someone, Praveen Devi. So when he sells this land, that the sale will be registered with the registrar under Registration Act, which I will be covering in next slide. After the deed is registered, this person will bring his deed and application to the revenue authorities. They kindly make a change in my land records also. That is record of rights also. So whenever there is a then the Patwari will enter in this mutation register first. First part of this mutation register is the existing entry, and second part of the mutation register is the proposed entry because of this deed registration. No, just show earlier slide, mutation register. I'm talking about mutation register. So mutation register, there are two parts. First part is basically existing entry, which was appearing in the previous Jamabandi I showed you. The second part is because of the change in the ownership. This is the proposed entry. So on this mutation register, it will be put before the revenue officer. He will call the parties, hear them, and if there are any objections, he will hear them, and then he will record his order on this, whether it is sanctioned or it is rejected. Once it is sanctioned, I think show me the last column, report of Hukmaran. Yes, this is last column. It says it has been sanctioned.
Can you show the heading also, Siddesh?
This is the report. Yes. Report of Hukmaran, I think. Report, yeah, Hukm, order. So report or order. So here the mutation is sanctioned. Once the officer signs it, in another copy the detailed record is there, but here just said that it is sanctioned. After it is sanctioned, kindly next slide. Show the next slide. Yes. No, next. Yes. Jamabandi after mutation. It is same Jamabandi, but now in Khania Kaifiyat. Please zoom it. Please zoom it. Last column. Yes. In last column, it says, just let's see. That this with reference to this note, now this ownership has been transferred in favor of Praveen Devi from Surinder Kumar. So this operation is complete now. Record of right has been changed. When the next copy of Jamabandi will be written, this details of remark column will appear in the third column. At present, it is in the remarks column because it has been recorded on the existing Jamabandi. When after 5 years next Jamabandi is written, this instead of Surinder Kumar, Praveen Kumari will be recorded as owner. So this is the way the record of rights are changed. Most important thing is here, every entry here is changed after adjudication. There is a revenue officer, parties are heard, there is a procedure, and objections are obtained, and then only record is changed. And that's why it has a legal standing. I assert that presumption of truth is there because the entries cannot be changed just like that. They can be changed only after adopting a legal process. That's why the presumption of truth is attached to these entries. So next, please. So now I have shown you. I am just showing some characteristics. The register of ownership. I have told you that this main register is called with different names in different states. I will show you in the next slide. I showed you Himachal Pradesh where it is called Jamabandi. Then it is updated in say 1:5 years periodicity is different, but mostly in North India, I've seen 5 years. And it records ownership, possession, area, and category of land, land revenue, etc. against each parcel of land. Now you can see that I have listed out names of these record of ownership. In Andhra Pradesh, it is called record of right 1B because it is made on 1B form. In Bihar, it is called Chalu Khatia. In Delhi, it is called Khatoni. In Karnataka, RTC book. In Maharashtra, it is called Satbara because it is combination of 2 forms, form number 7 and form number 12. In Punjab, it is called Jamabandi. In Haryana and Himachal also, it is called Jamabandi. In Uttar Pradesh, it is called Khatoni. In West Bengal, it is called Khatia. So what I am saying that actually names are different, but actually it is record of ownership, which is almost on same pattern in every state. There might be minor differences in the form, but almost on the same pattern. Next, please. Mutation register. Next. Yes. The previous slide was shown or not? I think I have just show the previous slide. This slide. I think I have shown you this thing that in Andhra Pradesh it's called ROR 1B, Bihar Chalu Khatia, Delhi Khatoni, Maharashtra Satbara, Punjab Jamabandi. So these are different names of register of ownership in different states. Next. So mutation register, I have told you that it is used for making changes. So any entry is first recorded in the mutation register, then there is an order of the revenue officer, and then only it can be transferred to the main register of ownership. And if a person is dissatisfied with the order of the revenue officer, then he can go in appeal. Okay, next please. Now, cadastral maps. So I have shown you cadastral map, but just to tell you about something about the cadastral map. So you have seen Survey of India maps. Google Maps are actually Survey of India maps. So, but these are on very small scale. That is 1:25,000. So Survey of India makes the maps on scale of 1:25,000. This is the largest scale they have available to the public. So there you cannot see the individual land plots. You can see roads, you can see some buildings, some major buildings, but you cannot see the individual plots. The cadastral maps are prepared by the revenue department of the state government, and that is weakness of this. That's mostly not aligned to Survey of India maps. So basically, they are prepared independently. Ideally, they should align with the Survey of India map, but actually, it is not happening. So, except in southern states, cadastral maps are on the scale of 1:5,000 to 1:500. So 1:5,000 means that 50 meter is equal to 1 centimeter on map. But in some urban areas, map may be still larger. So 5 centimeter is 1 centimeter, but it depends changes from area to area and state to state. In southern states, actually this cadastral map I showed you of Himachal Pradesh, they are not prepared in this form. They prepare maps of individual plots separately. Those are called tippan. So a detailed map of each plot is available separately, and there is a field book in their measurements are recorded. But there is an index map on a smaller scale where you can see the number of plots, but it is not to the scale. So there is an index map. You can see the number of khasra from there, plot there, but then you have to refer to the tippan for a detailed map and the field book, and then the Jamabandi or whatever they call it. So this is a difference in maintaining the record. So in North India, the whole mosaic is maintained in one map, but in South India, they use tippan of individual plot numbers, but not much of difference. And as you know, that unique identification number is assigned to every parcel of land, which is called sometimes khatra number, a plot number, or whatever. Next. Now I told you about the presumption of truth is attached to the entry. What does it mean? Mean that this is legally that entry will be taken as true unless proved otherwise. So exact provision of the law I have quoted from the two acts. You can see in Maharashtra it says an entry in the record of rights and a certified entry in the registration of mutation shall be presumed to be true until the contrary is proved or a new entry is lawfully substituted there. Almost same provision is there in Punjab Act also. An entry made in the record of rights in accordance with the law or the time being enforced or in an annual record accordance with the provision of this chapter and rules thereunder shall be presumed to be true until the contrary is proved. Now, this is, as I told you earlier, this is strength of our cadastre or record of rights. But nowadays you will read many articles if you say presumptive record, conclusive title, presumptive title. So it has been projected as a negative characteristic of our records. So you will read many articles, they say our records are presumptive. So that's why people are not sure about their title. It is not so. Our system is this, that cadastre is maintained in this manner only. Only thing is that cadastre has been given some strength by this law. So next. So now I have completed my whatever I wanted to say about the record of rights. If any question is there on this, kindly ask.
Yes, sir. There was one question. What's the difference between Khatoni, Khewat, and Khasra? There was yes.
That's why I tell you these are local terms, so they will vary from state to state. So you have to see what for what state you are talking about. That's why I have given you English terms, generic terms. There is a cadastral map. I know in Himachal Pradesh and Punjab this is called Khasra map also. Okay.
Okay.
But
okay.
it may mean something else in UP. I am not sure.
Okay.
So the basic records are 3: cadastral map. So there is a map. It may be called by whatever name in local language. Then there is a record of ownership, register of ownership. It may be called by whatever name in different states. And third is, I told you, mutation. So let us stick to that. This local term you have to understand from the concerned act.
Okay, and will vary from state to state.
This varies from state to state.
Vary from state to state. So another 2 students have asked related to some which are related to GIS. One student says that probably GIS can help in compiling all those 4 documents that you showed, and another student.
What is the organization? I could not get.
There were 4 documents which you showed. The mutation one. Yes. So all those 4, he is saying probably if they are put on GIS, it can help in organizing the records in a better way. And another student, another question which is related to this is that have any state started digitizing any of these maps on GIS?
Yes, I tell you. Lot of possibilities are there. As you are saying that this can be put on GIS, of course, lot of possibilities are there. Many states, actually every state is going in its own way in computerization and digitization. Right. So many states might be doing that also, but many may not be doing. I still feel that lot of business process re-engineering should have taken place along with the computerization. But unfortunately, it has not happened. Mostly what has happened is that mostly the old, sometimes they are archaic, those procedures have been computerized, which is not very happy state of things, but it is so. Second thing is that I will not be able to tell you which state has done it, because that you have to go from state to state. There is almost all the state governments, they have websites on which the details of computerization and digitization have been given. You can go through that. There is a central, there is a website of Ministry of Land Resources also, Department of Land Resources. So there also they have given state-wise details. So you have to,
Okay.
you can see
Uh,
that. Okay. Please,
So there
please.
is, yes, sir, there is one question that I have related to this GIS, because after having all these, I think a lot of states are going digital with this, but uh, some critics also say that there are a lot of data security concerns related to this, and that should be taken care of when we are digitizing, because once anything goes in a system, a computer, you that is the record, and if proper data security is not in place, it may be very easy to tamper with these ownership documents. So
There are two things I tell you, because
yes.
now these programs are mostly now have standardized. Like for now, NIC has also worked on that. So some private companies are also working, but now NIC has the program. Most of the states, I think, may be following the NIC program. They call it Bhu Naksha for cadastral maps. So the usual security protocols are always there, because these all those websites are certified, security certified, etc. But certainly, there can be, depending on the specific requirements, certain security measures can be built into that. So that depends when you analyze the system, what kind of security requirement you have. So it will depend on your software. I assume that those softwares must be following the security protocol. But because you have raised this thing, now a latest thing is using blockchain for the
Right.
maintenance of land records. So there's a lot of talk about it. I am not very sure that any state has actually implemented it. I have been told that, probably in Telangana, some serious work is going on this, because the blockchain ensures that, no one can change the record without, consent of other stakeholders. So
Right.
that is basically, this is such a dynamic field that every day new things will come and you can keep on improving your system. Okay.
Right. Okay, sir.
So,
So we
so now we'll
can.
proceed.
Right.
So now the second part is registration of land transactions. Next, please. You have changed the slide. Yes. So registration. What is actually registration? Registration is recording a private transaction in public record. So as I told you that rights in the land are considered just in rem, rights against the whole world. So the whole world should know about your rights. And that is the purpose of registration. So that everyone knows that which land is owned by whom, and so that there may not be dispute, there may not be multiple transactions about the same land, there may not be frauds. So that's why this registration concept is there. So I think that we have discussed it, that why we want registration of rights in land, because the difference in ownership of land and other property. Character of rights in land is different. Notice to the word is required. And this, once this is registered, in case of dispute, we can decide the priority when which transaction took place on what date. So then the courts can decide that which is valid transaction, which is invalid transaction. And once the facilities for title search, if someone wants to buy the land, so then he can search the records of the registrar and know that, what is the history of that land, who actually purchased, who actually sold. So this registration facilitates title search in the land. Next, please. So there are two systems, major systems of land registration. One is called deed registration, and second is called registration of title. So deed registration is what we follow in India, and registration of title, I will tell you some basic characteristics of this. Next, please. So registration of deed or recording system, they call, in USA they called it recording system. In India we call it deed registration. So the most basic characteristics of this system is the transfer of title through a transfer deed. When you transfer of title, means ownership is transferred once you sign the deed. Once you sign a deed, when the deed is signed between the two parties, then the ownership is transferred and transaction is complete. But only for record purposes, you are going to the registrar and getting that transaction registered. So actual transfer of right takes place when deed is signed or deed is executed. So record registration is for the record purposes. And registration does not guarantee good title. I will discuss this concept further. What does it mean? Registration of deed does not mean that transaction is valid. In registration of title system, transfer of title by registration means transfer takes place only when it is registered in the record. Before that, whatever you do, it is not a valid transfer. Once you come to the registrar, record the transaction, he records in the register, then only title gets transferred. So this is the transfer of title by registration. There, in deed registration system, transfer of title took place when you signed the deed, but you came to the registrar to just register that deed for record purpose. Then registered title is indefeasible. There is, I told you that the presumption of truth and conclusive title means. Registered title is indefeasible. Indefeasible means that it cannot be challenged. So if something is recorded in the register, it will be taken as true. It will not be presumed to be true. It will be taken as true. Suppose someone, even if the entry is wrong in the register, but it will be considered as true. But if someone gets someone is harmed by a wrong entry in the register, then state indemnity against any defect in the title. If register is wrong, then state will compensate that person who has got some loss because of wrong register. In deed registration, state bears no responsibility. You will be satisfied and buy the land. If there is a law, if there is a some defect in the title, you have to bear the consequences. So that is the basic difference in two systems. Next, please. In theory, it will always appear that title registration is very good. It gives certainty of title. It compensates the person who is at loss. So why we are having deed registration system? It is not so. There are many legal consequences of every system. So just for your information, I am listing out that almost more than half of the countries may be using deed registration system, which we have, and less than half may be having title registration system. So both systems are very popular. It mostly depends on the peculiar history of that country and then peculiar type of land rights in that country. So it is very difficult to say that this system is better or that system is better. The system is better which we implement well. So among the top 10 economies in the world, USA, Japan, Italy, France, India, Brazil, they use deed registration system. Germany and the UK, they use title registration. In Canada, in some provinces, title registration system is there. In some provinces, deed registration system is there. So they are using both the systems. In China, it is told that title registration is in the process. Not much details are available. So I just want to emphasize that both systems have equal popularity. So we cannot just say that this system is good or that system is good. Next, please. Now, features of registration in India. India follows deed registration system, and it is done under Registration Act of 1908. Originally, registration was introduced in India by the Britishers as early as 1793. At that time, there was no registration in UK also, there was no registration in France also. They introduced very early, but now the present act which we are using is Act of 1908. Here also I would say that 100 or 111 years have passed. There have been very, very little changes into this act, which should have drastically changed, looking into the modern requirements. Registration is compulsory for most of the transactions. So under this act, most of the transactions in land sale, purchase, mortgage, gift, they have to be registered with the registrar compulsorily. Okay, so this is compulsory for them. There are some exemptions like inheritance. Suppose I succeed land from my father, it is not required to be registered because there is no deed, there is no transfer deed, so it will not be registered. Court decrees are not registered. Court decrees, suppose they award title to someone, but still it is not registered. It changes the title, but it is not registered. If government grants land to someone, it is not registered. So there are certain exemptions. Any transaction below 100 rupees is not registered. So there are certain exemptions in this, but mostly transactions are required to be registered. Then it is the responsibility of the buyer to verify the title of the seller. What normally he will do with the assistance of one attorney, that he will see the past records. Normally one would see, say, past record of say 30 years or so. He will see the record of registration also, and he will see the record of rights also. And there he will try to find out whether this is the uninterrupted ownership. There is no problem, there is no litigation. Then probably he will buy. But still, in spite of this, there might be mistakes. But it is the responsibility of the buyer to search the title, be satisfied, and then buy. If there is any problem, he will bear the consequences. And in registrar prepares grantor, grantee index, and tract-wide index maintained by the registrar. What they do is that all the deeds are registered, so an index is prepared. Grantor grantee index means that with the name of the person. So they will arrange alphabetically name of all the purchasers. So name of Ramlal, Shyamlal, and Ramlal. In front of Ramlal, they will write through this deed number, this land, he has purchased this land. Now you can go to the original deed, you can see the record. Similarly, they will arrange name of the seller in alphabetical order. In India, in many other countries it is not done. In USA it is not done, but in India, tract-wide index is also prepared. So an index is prepared plot number wise also. That this plot number, it has been sold by this one, it has been purchased by this one. So it is still easier to search the records because normally you see the plot number which you want to buy. So this is the index through which title search can be made. And after getting reference from the index, one would see the original deed, so that he is sure that actually whoever is selling, he actually owns the land. Next, please.
Sir, I had a question related to that. What is the purpose of the grantee index? Can you go to the previous slide?
Yes, please.
There are two indexes which you are referring to. So what is the
grantor means? I tell you. Grantor means the seller, the person who is giving the land. Either he may be donor or a seller. Okay. So then, because suppose you are going to buy a land. So you are buying from Ram Prasad. So you know his name. Now you will try to search whether the same person has sold this land to someone else. So if the name of Ram Prasad appears somewhere in the grantor, you will become suspicious and you will like to see the deed. And you say the deed that if this deed does not mention the same land which is offering to you. Okay. Then in grantee index also, you will try to find out name of Ram Prasad, because say 10 years back he had purchased this land. So his name should appear in grantee list. Then you will see the deed and you will find out that he has actually purchased this land. My land is mentioned so that you are sure that he is owner of this land. So that is the purpose of this.
Okay, so with the current system of records, it would be so difficult to go through all the files and actually find the list. So this, I think, this entire process might be very well facilitated if it is, if it were all in a digitized
yes, it is there.
system.
You are absolutely right. It is very,
Okay.
very difficult. It is one of the huge weakness of our system.
Of our
Because the
system,
search very,
right.
very difficult. And search you don't have to only make here. Probably you will go into municipal records also.
Right.
Something might be there. Something might be there in the record of rights. Okay, which is not appearing. Suppose inheritance will not appear in the record of the registrar.
Okay.
Because there is no, so inheritance will appear only in the record of rights. Suppose someone says that I have inherited this land from my father. So you have to see from record of rights that this person actually has inherited, or there is no other sister, or what is his share. So all those things you have to search.
Okay.
So this is the major weakness, but you are right. Wherever the records have been computerized, then this is a question of seconds, because you will put plot number, and against that plot number, the computer give you all the details.
All the details.
Previous transaction. Right. So that is happening in Maharashtra. They have done it. So now search is very easy. Okay.
Okay. Siddesh, next slide. Yes.
Okay. Next. I think we are on the process of registration. Yes, process of registration. So this is, I have told you almost, but this is the process of registration in India. That first there is a agreement to sell between the parties. This is the initial agreement, and sometimes some earnest money is exchanged on the basis of this agreement. After that, you will pay amount. That also depends on your agreement between him and how the amount is to be paid. Then handing over of the possession. It may happen at any stage depending on your understanding with that person. Then you will record a deed. Deed will be written, in which clearly it will written who is selling, who is purchasing, what rights are being sold, what rights are being purchased, what are the any limitation on the rights, etc., etc. Then this registration payment, then you have to pay stamp duty. So depending on the value of the transaction, stamp duty is payable. Stamp duty is payable under the Stamp Duty Act, not under the Registration Act. So Stamp Duty Act prescribes various rates of stamp duty. So it is paid by depositing in the bank and purchasing the stamp paper. Or previous system was that you had to purchase physical stamp papers. So now you have to pay the stamp duty, and then registration of that deed with the payment of registration fee, which is a comparatively smaller amount, but that is another fee which has to be which is payable. So once the deed is registered, then you will go to the revenue authorities for recording your change in ownership in the record of rights. That completes the process of registration in India. Next, please. Now, what is the legal standing of the registration? I told you about the record of rights. That legal standing is that it is presumed to be true unless proved otherwise. So that was the one legal support available to the record of rights. Now, what is the legal standing of the registration? First thing is that there is a legal principle. It's called nemo dat. No one gives what he does not have. Obvious. No one can give what he does not have. But it is very obvious in case of movable property. If he does not have something in his hand, he cannot give you. But in case of immovable property, it is very difficult to know. As I told you that on land, ownership means a bundle of rights. So the person who is selling those rights to you, he should actually own those rights. So no one gives what he does not have. So this legal principle is applied in the registration in India. So even if the registration takes place, if the seller does not have a good title, title will not be transferred to you. Next, registration. Sorry, previous slide. Previous slide. Yes. Registration is yes. This slide, please. This slide. Registration is only an evidence of transaction, not a conclusive proof of title. So, if a deed is registered, it does not mean that title is actually transferred to you. As I have earlier told you that if there is a defect in the title of the seller, the purchaser will carry the same defect in the title. Validity of transaction not examined by the registrar. Registrar does not examine the validity of the transaction. That is not written in the registration law. He examines only the formal requirements, that deed is written in a correct format, the witnesses are there, the parties are identified, stamp duty has been paid, that's all. And then he will raise, and that parties are present before him. They accept the transaction. So that is what registrar does. Registrar does not examine the legality of the transaction. You people must have seen Bunty and Bubbly picture. Must have seen. You remember
Most
that
of
there,
them must have. Yes.
huh?
Yeah,
Pardon?
most of them might have.
Might have.
Yeah.
You remember that Abhishek Bachchan and Rani Mukherjee, they sold Taj Mahal to a foreigner.
Right.
They sold Taj Mahal. Actually, it is possible theoretically, because the purchaser has to satisfy himself about the title of the seller. Registrar does not object to it. So you can sell anything, but the purchaser will not get the right on that because you did not have the rights. It may be a piece of fraud, but registrar will not object to it. He is not mandated to object to it. So registrar does not examine validity of title in the during the process of registration. Then, but as I told you that registration is compulsory. So what does it mean? If registration is compulsory, then if something is not registered, there should be some consequence of that. Then only you will go to register. So consequence is that it is written in the registration law that if a transaction is not registered, it will not affect the land. So that means transaction, you can say that it is invalid. If you buy something from someone, the deed is executed, money is paid, possession is taken, but it is not brought to the registrar for registration, then actually that transaction will not affect the land. That person can very well sell this land to someone else. You may have a civil claim against him, a claim of fraud or something, but otherwise, your transaction is not valid unless you register it. But unfortunately, converse is not true. If it is registered, it does not mean that it is valid. So registration does not, non-registration will make a transaction invalid as per the law, but registration not necessarily makes the transaction valid, because that will depend on the title of the seller. If he does not have a title, the transaction will also be invalid.
So is it the responsibility of the purchaser to have clear evidence of the proof or proof of title?
Absolutely.
Okay.
It is the responsibility of the purchaser.
And
Suppose
if,
someone plays fraud with you, the seller is playing the fraud with you. You may have a claim of fraud against him.
okay.
I know, but what happens? Suppose I will give you one example. For example, a father died and he had a daughter and a son. So as per law, the daughter and son should get equal share. This person hid this fact from the authorities, and in record of rights, he got his name registered for full share. Okay. Now, on the strength of that record of rights, he is selling this land to the purchaser. Purchaser is also not aware because he has seen the record of right. In record of right, it is written.
Right.
Now he has purchased this land. But even if after 10 years, sister comes, or even sister's son comes, and he says that our right was not taken care of, and half of the land belongs to me. So she will have a claim against the purchaser, and the purchaser will have to bear the consequences. He may recover money from the seller in a civil suit. That is a different issue. But the sister will get the land. This is the peculiarity of deed registration law. It does not happen in the title registration law. In title registration law, what will happen? If sister comes with a claim, then the purchaser will possession and ownership of purchaser will not be disturbed. She will be paid out of the indemnity fund. The government will say that yes, there was a genuine mistake, or our authorities did not verify the title at that time before recording. So now we will pay you from indemnity fund. So she can get the money, but not the land. That is the difference between the title registration system and deed registration.
Okay,
But only
sir.
thing is that it appears easy. But if you adopt title registration system, then at the time of registration, lot of inquiries your registrar will have to make. That will slow the process. That may inbreed corruption also. Okay, so there are many consequences of that. So here, the registrar has simple duty to examine the formal requirement. The consequences have to be borne by the parties, and parties know about it. Now you are asking something?
Yes, there is a question from someone else. In case of urban records, only conveyance deed is done. In case of Haryana, no mutation for townships developed by developers. So in this case, is conveyance deed equivalent to the title registration?
No, just tell you. Let us understand. First, when I discussing about the record of right, I told you that law regarding record of right is equally applicable to urban areas and rural areas. So legally, there should be a record of rights for urban areas also, and mutation should be recorded there. But that is true. It is not being done because the record of rights in the urban areas are not being updated in most of the places. So now what happens? Suppose there was you buy a land in rural area. So you have a deed, then you get it recorded in the record of rights. As I told you in the previous case, that the brother has got his name recorded in the record of rights. So now he has an additional advantage of an entry in the record of rights, which has a presumption of truth. But status of his title does not change. The right of sister was not abolished because of entry in the record of rights. Only thing is that it got little more strength because the presumption of truth is there. So when sister goes into a litigation, then even record of rights will be disputed, and this transfer deed will also be disputed. So same thing in the city. In city, only transfer deed is there. Entry in the record of right is not there. So status is same. Status is same. The legal law is same. Law says that transfer deed does not ensures the validity of title. Validity of title will depend on the nemo dat principle. One gives whatever he has. So if the seller had a good title, you will get a good title. If seller had a defective title, you will get a defective title, whether mutation is done or mutation is not done. Okay?
Oh, okay.
Is that clear, or any further clarification?
I hope that must be clear.
Okay.
Otherwise, she can again ask you at the end of the
Okay.
session.
Okay, okay, fine. And this issue I will discuss when I discuss with problems and solutions also. Okay.
Right, right. Yes,
So,
I think she's saying she has understood it. Oh,
okay, thank you.
all right.
Now, so I finished this part of land registration, and I will move to part 3, that is the land information system. Land information system, basically, in generic terms, you can say that traditionally land information system was, this is information system is through what means you can know about the land, you can know about the rights. So traditional information system was maps, cadastre, manual cadastre, and other registers by the revenue department, periodical reports, abstracts sent to the higher offices so that you know that, well, many things you can know from that. So some summary of information. And indexes maintained by the registrar, as I told you, grantor grantee index or tract wide index. This is the land information system in a manual system. But modern land information system is digitized maps and cadastre and online access to the all stakeholders. So this is the information system. Next, please. Okay. So just to I told earlier also that Government of India has a program that is called Digital India Land Records Modernization Program. Through in this program, they have decided certain principles and give grants to the states, but states are free to select the vendor, select the system, select the software, and go for the computerization of land records. Next, please. What is actually happening in this? Computerization of record of rights and cadastral maps. So record of rights was easier. That is the register of ownership and mutation register, etc. Cadastral map was a little difficult, but now the systems are in place and then software, etc. are there. Now, as I told you, the NIC has a software, Bhunaksha. So most of the states are following that. On the basis of that, this computerization is taking place. Then the computerization of registration process, which is a separate process. So registrar office is being computerized. I have seen in Maharashtra they are fully computerized, and it has become very easy for search of records, etc. Then web-enabled services to the common citizens. Some states have actually given those services to the common citizens. People have first apprehension whether they can give land records on the web or not. But now I think most of the states now following this thing that web records are available on internet, websites. Even you can go to any website and see the record of any person, and I think it is correct also because it's a public record. Everyone should be able to see that. Then MIS for the better land administration. On the basis of that, MIS are being prepared, so a lot of reports can be generated. And there is a talk that even planning department, town and planning, and urban development authorities, they should also use the same platform. Some states might be doing it, where situation differs from state to state. And then updating of record is also taking place through computer. As I showed you that after the sanction of mutation, the remark comes in the new Jamabandi, and then when the next Jamabandi is printed, then ownership column will change. So now the Jamabandis are being written through computers only. There is no need to write manual record of rights. And then different departments, flow of information can take place between different departments. Like when the planning department wants to make a master plan, then probably they can directly take cadastral maps and record of rights of revenue department and build their another layer of master plan over the same cadastral map. Next, please. But some observations are there. My observation: the process has been abysmally slow. I know that this was started in Kangla district, and I was ADC in 1990. I made the first project report for Himachal. but still, work is, but now Himachal has completed, but still it has not completed in whole of the India. So the work has been very, very slow in this. Second thing is, which pains me, is that business process re-engineering has not taken place. The poor computer engineers, they have struggled to computerize the very, very old procedures which were not required. As someone mentioned that all the maps can be combined, all the records can be on GIS, all those things can be tried done. Rather, formats can change, many columns are not required, but still, because the computer engineers were told, no, you have to get exact printout like this only, you have to follow the same procedure. So a lot of effort has gone into it to computerize, to understand those procedures and computerize those procedures, and the upgradation of processes has not taken place. This I feel. So, and in the law, for almost 150 years, no change has taken place. That was a good opportunity when we could change our law at the time of computerization. It has not been done. I feel so that certain procedures we have automated, but actually the real change in the land administration has not come. This is my observation. Or second thing is that what we are doing when we do computerization, we are improving a tool, but we are not improving the master. Master is the law. So if law is old, law has severe limitations, then you bring a better and better tool, efficiency will not come, and that is actually happening. What is happening in some states has gone sort of a inaccuracy, because now there is a possibility of mapping through drones and through aerial survey, etc., and then very, very accurate equipments are available. So we are increasing the accuracy of the measurement, which is probably not required in case of rural range. So I mean to say that kind of thought has not gone into the computerization in general. I am not aware, in some states work might be being done. I am not very sure on that factual, but in general, I have seen in few states we have not worked on BPR. So about the computerization, I want to say this thing only. If any question is there, then I will try to answer.
Anyone has any questions in this section? You can maybe write it in the chat box, or we can continue otherwise.
Okay. So I think now I will go to the part 4. This is the problems and possible solutions. What are the problems normally we perceive in this system, and what can be possible solutions? Possible solutions which I feel that should be done. Naturally, there can be many more things. If people join their mind together, then many more things can be. This is what I have thought of, and I have written in my book also. So the problem in the existing system is, first thing is that land dispute dominates civil litigation in India. There is a recent Access to Justice survey in 2015-16 by an organization Daksha. They say that 2/3 of the dispute in the civil courts are relating to land, which is a very high number. Though exact analysis is not available, but I have tried to find out in European countries, etc. See, those many disputes relating to land are not there. Now they have mostly disputes relating to corporate affairs, dispute relating to patent laws, to intellectual property, but not so many disputes about the real property. But in our country, we have 2/3 of cases relating to land, which is a serious problem. Then, apart from the civil courts, the plethora of disputes before the revenue office. Revenue officers, they have a lot of disputes regarding inheritance, correction of record of rights, demarcation of boundaries. So that is also a huge number. Then, as we have discussed repeatedly over in the last part, that ownership recorded in record of right is not a conclusive proof of title. In urban areas, record of rights are not updated regularly. That is a serious problem. Next. I think this slide was shown. Now this. Now in urban areas, record of rights are not available. But as I told you, that law on record of right is equally applicable to urban areas. But I also feel that the formats given in those laws are not suited to the urban areas. Because in urban areas, you have multi-storied building, you have common lands, so you have to record the rights on flats. You have to you have to record the rights on common land in a condominium. So that kind of formats are not available because those formats are made for the agricultural land. So this is another problem, and that is the probably because records are not being prepared in urban areas. Then, as we have discussed, the search of multiple records required to a certain title of a seller. Registration of deed is no assurance to valid title. There is no way to know about. This is a serious problem. That about a land, certain litigation may be going on in the court, and we have no way to know whether some litigation is going on in the court. Our Transfer of Property Act says that if there is section 52 of the Transfer of Property Act says that if there is a litigation about the land, then a person can sell that land, but the purchaser will be bound by the final decision of the court. So suppose there is a I gave you example of brother and sister. Suppose the dispute is going on, so sister is claiming half of the land and brother has recordings in his favor. Meanwhile, he sells the land to another person, whole of the land. The person they had no way to know whether litigation is going on, because in the record of right, name of brother is there. There is so he has no way to know. He purchases that land. After say 10 years, if the court decides and grants half of the share to the sister, then this purchaser will also lose half of his land. It will go to the sister. But at the time of purchase, he made all the search in the title, but he had no way to know whether any litigation is going on about that. So this is weakness. Transactions appear in record of rights and registration after considerable gap of time. Actually, 4 months are allowed. After a transaction takes place, deed is signed, then within next 4 months you can go to the registrar and get it registered, and it will be considered effective from the date you signed that deed. So suppose 2 persons agree and sign a deed today, and they go to the registrar after 4 months. He will register it, and then the deed will be effective from today only. Now imagine a situation in which a deed is signed today and the same person signs another deed tomorrow to a third person, some other person. That person will go for a title search. He will not see this deed anywhere because it is not registered. Now both will get this deed registered because within 4 months you can register, and then there would be disputes. So this is called registration gap. So there is a registration gap of 4 months in our law. Next, please. So these are some problems I listed out. Now what can be done? Some experts say, and if you search conclusive title on Google or title registration in India or something, you will find 1 or 2 articles on that. That some experts suggest that switching over to title registration system will solve all our problems. Because I told you that theoretically it looks very good, because whatever is written on the record is indefeasible. So seller, if he sees the record and buys the land, so the purchaser will have no problem. Okay, but there are consequences. Let us take that case of again brother and sister. If there was a title registration, then brother has sold the whole of the land, and sister, in spite of her genuine claim, will not get it. So in deed registration system, there was loss to the purchaser. In title registration system, there was loss to the genuine owner. Okay, so the consequences are on both sides. It depends what system you can manage well. So some experts suggest that it should be switched over, and Government of India also has this policy. If you see the policy document of 2008 of Government of India, it is available on their site. So the same document, which is a digitization of what is called Digital India modernization of land record system. In the same document, it is written that eventually we will adopt guaranteed title in India. So this is the Government of India policy. They have written to all the states, but till now, no state has been able to adopt it. Because once you come on the details, then you realize how difficult it is. But still, efforts are going on. Rajasthan passed an act in 2016, but it is just lying there. It has not been implemented. Rajasthan passed registration law for urban areas. Maharashtra has drafted such an act. I have hearing for last 1 year. Andhra perhaps has drafted some act and sent for consent of the president. So, but that's all. Activity is taken, but most of the states have not gone for it. So, I feel that it is preferable to improve our own system. Irony is that we have taken no efforts in improving the existing system in last 100 years or so. And we are talking about switching over to completely new system. So it probably is not prudent, but anyway, there would be debate will go on. But I feel that, and then another thing, what I say is that at least start improving our existing system. Then whenever you adopt title registration system, no problem. But at least, why have we stopped improving our existing system? So that is the idea that it is preferable to improve the existing system. And I have seen that, France, the Netherlands, and the USA. Previous slide, please. Yes, this is okay. They also have deed registration system. They have all made some improvement in their system. The France has introduced another document. They call it real estate file. The Netherlands has merged record of rights with the cadastre authorities and registration authorities. USA has a title insurance system which provides indemnity against a defective record. So they have made changes in the system. They have not completely changed over to new system. So what we can also do. That is my suggestion. Next, please. So there are some next, please. Okay. This is it. Possible improvements. Yeah. So there are few things I have listed out. There can be many more, as I told. But I feel these are very simple things which can be done immediately. Remove all exemptions from the registration. At present, I told you that most of the transactions are compulsorily to be registered, but there are certain exemptions. Law Commission, courts have recommended to the government that these exemptions should be removed. So there is a report of the Law Commission also, we say 6th report of the Law Commission, that all the exemptions should be removed. So immediately this change can take place. And otherwise also, as right in against whole of the bird, so everyone should know about every transaction. Why we have exempted certain transactions. We can exempt stamp duty, but not the registration. Second is reduce time allowed. I told you the registration gap. So the 4 months is a huge period. Nowadays, communications are so fast. I think not more than 1 month should be given to register a document. Actually, in our present law, 4 months are given, and then I can get 4 more months with the permission of registrar giving some difficulty. So 8 months can pass without registration. Same thing is there in record of rights also. So it should not be there. At the most 1 month. And another thing is that what we should do is that as soon as the deed is executed, we can prescribe that immediately within 2-3 days, a notice should be given to the registrar that we have entered into this transaction and we will be presenting our deed for registration. So that at least first information there is in the registrar. So any seller, any purchaser, when he makes a title search, at least he will see this notice and he will know, he will be alerted. In France, this happens. As soon as the deed is finalized, notary gives by the same evening, he gives a notice to the registrar. It is called priority notice. Registrar records it and it is displayed. Now he can take his own time to finally draw the deed and sign the deed. It may take a month or something, no problem, but at least alert is there. So this system can be here also. And in the record of rights also, 4 months should not be given. The person should go to the Patwari as soon as possible. I think 15 days or 1 month is more than enough. Then at present, as per law, as I told you now, that one can sell Taj Mahal also. So one does not have to show his ownership even prima facie, because registrar does not examine any document. He is not authorized to examine. I feel that now is a time that at least prima facie examination by the registrar should be allowed. Proof of ownership. But he may not be given too much power. At least he can see the record. At least this should be prescribed that your name should appear in some government record. If not record of rights, at least in the municipal record, in the tax record, somewhere. So some prima facie evidence is there. So, that will not prevent, that will not be very, very foolproof, but at least it will reduce uncertainty to some extent. In the Netherlands, what they have done, they have given registrar, they also follow the deed registration. They give registrar power to object, but only make one objection. So if registrar feels that this transaction is invalid, he can give notice to the party, to the seller also, to the purchaser also. He just write that, I feel that this defective transaction is there. But even after his objection, if the parties insist, he will register. So at least he sends one alert to the seller that you be satisfied, I have this problem. So this kind of thing can be there in our law, which is not very difficult. We don't have to change the basic principles of the law. Next. Then in India, the registration of wills is provided, but it is not compulsory. So after death of a person, there may be a will, registered will, there may be an unregistered will, or there may be two unregistered wills, because sometimes you might have written multiple wills, or some people may be creating wills. So a lot of disputes occur because of the wills. So if the wills are compulsorily registered, then this problem will be solved to some extent. And the Parliamentary Standing Committee has recommended to the Department of Land Resources that this should be done. So what I am saying, that this is recommended by the Standing Committee also. So this can be implemented very easily. Compulsory registration of court decrees, that is also required. Till 1866 in India, all the decrees were to be registered. There was a provision that civil court will send a copy of the decree to the registrar, and the registrar will register it, and it will appear in his indexes. But after 1866, this provision was removed. In Karnataka, there is a provision in record of rights law that court will send a copy of the decree to the revenue officer, who will make an entry in the record of rights. But that is for the record of rights. So I mean to say that everyone accepts that this should be there. In a Supreme Court judgment, this is called T. Ashok Kumar versus Govindamal case in 2011. The Supreme Court has recommended to the government that all the decrees and pending litigation must be recorded somewhere must be registered. But the requisite change in the law has not taken place. This is immediately required. So a compulsory registration of court decrees and compulsory registration of pending litigation. I have told you that principles are already decided. Supreme Court has recommended. Yes, Law Commission has also recommended about this to the government. So the issues are examined already. They can be implemented. Then no transfer of share without making new maps of property. It happens actually. People sell shares. So now in the registration law, there is no requirement that if you are selling the share, the new map should be created, and so that the boundaries are fixed. Otherwise, later on disputes take place. So I think there should be a law. It should be provided in the law that part of the property will not be sold unless the new map is made and it is approved by the concerned authority. And then new map should be made, and the private sector should also be involved. Private surveyors. In Karnataka has licensed private surveyors. In most of the states, still we depend on government authorities who do not have time. So the private surveyors will make the maps, new maps, and then they can be certified by the revenue authority. Then prompt disposal of disputes by the revenue officers. That is big problem in our system. Huge number of cases there are revenue authorities regarding the mutations, correction of revenue entries, disputed wills, etc. And these cases linger on at multiple levels. The Tehsildar, then the appeal will go to the SDM, from SDM it will go to the collector, up to the financial commissioner, and then all the appeals are exhausted. Then person can go in revision or review. Powers have been given to the financial commissioner to review the cases suo motu. So after 10 years, when person has lost all the appeals, he will go for review, and maybe that his case is reopened. And the civil courts are always there. He can go in writ petition or somewhere. So what has been seen, that multiple litigation is happening before the revenue authorities, which is actually not required, because revenue authorities decide only what entry is to be made in the record of rights. They do not decide the right. For example, again, let me take that example of brother and sister. When the Tehsildar wrote the name of the brother, he just gave a decision that brother's name should be written here. He did not give the decision that this land belongs to the brother. He cannot give that decision. That decision is solely the jurisdiction of the civil court only. So for just making an entry in the record, why so much of litigation? So what I feel, that multiple appeals should be just removed. There should be only one appeal. And then if person is dissatisfied, then he can always go to the civil court. In Karnataka, in West Bengal, only one appeal is provided in the revenue law. But in Maharashtra, in Punjab, multiple level of appeal and cases are linger on for 10, 12, 20 years. That can be. Next, please. Another problem happens is that I think we have, there's some time. Yes. So our succession laws are very complex. Succession law, there are two complexities. One is that succession laws depend from community to community. So here succession law is different from Muslim community, different from for Hindu community, different from Christians, and maybe within Hindu community or within Muslim community also, as per customs of that area, the succession laws may be different. And wherever law is not written, the customary law has to be followed. So first thing is that it is very difficult what to write in the record of rights when the person dies, because it depends on the customary law. Say Hindu succession act is codified, so for Hindus the written law will be followed. But written law is also very complex. Just I will give you one example. Every Hindu may be owning two types of property. One is self-acquired property, another is which is called ancestral property. Okay. On ancestral property, I might be cultivating, my name may be recorded. Okay. But I have limited power to transfer that property. Suppose I got ancestral property which was coming from my grandfather. So I cannot, legally I cannot sell it without the consent of my son or daughter or son's son, because they are called co-partners under Hindu undivided family law. In Hindu undivided family, there are many co-partners. Co-partners means shareholders. So actually ancestral property is shared by all. For self-required property, yes, you are your own boss. So there are a lot of disputes, because but in record of rights, this distinction is not made. This distinction is not made. Suppose a father dies, he had only one son, so he will get all the property will be recorded in his name. Then this son buys, after 10 years he buys some piece of property, that will also be joined with the same khata, right, recorded in his name. A purchaser comes, suppose a purchaser purchases the ancestral property. His son was minor at that time. The one son gets majority, he can go and challenge that father has compromised with my interest and this property should not have been sold. It was sold very fraudulently or very less amount, something, and he will have a valid claim against that property, because father was not authorized to sell that property without the consent of all the co-partners. So one simple reform can be that we can record ancestral property and self-acquired property separately in the record of rights. Then if when the seller knows that it is ancestral property, he will check the law, he will find out, he will see the history, but at least he will be alerted. Okay. Then yes, computerization of land records we have discussed, that is very much required, it is happening also, but with business process re-engineering. Then another reform can be tried, and I feel that in urban areas it should be immediately done, is merger of record of rights and registration. Legally, merger is very difficult because these are two separate acts. What can be done? At least the work can be given to a single authority. Maybe that to the municipal authority only, municipal commissioner or assistant commissioner in the municipal committee. He will be responsible for registration also. He will be responsible for mutations also. Then a lot of synergy will take place, and I think record will be better maintained. So this reform can be tried in urban areas. And let me tell you, whatever problems regarding land we discuss, mostly they relate to urban areas, because land is costly there. Their land assembly is taking place. Their number of transaction is very huge. In rural area, that there may not be much of problem. So we have to find the solutions mainly for urban areas. Then new formats of ROR I mentioned earlier also. You have to have new formats for ROR for urban areas. Many countries are working on 3D cadastre, because in multi-storied building you have to record ownership. So something of that kind we have to think of. Otherwise, on traditional record of rights, we cannot record urban land. Then another thing can be, once we are computerizing, then this should be system of automatic alert to landowner regarding any change, because now I think in all the land records, Aadhaar number, SMS, email must be there. It may not be happening, it may be happening in some church, but it should be there. And what I feel that like bank account, it is my account, which is being maintained by the government. So if any change takes place, an alert should come to me. Actually, the new technology of blockchain is that kind of similar. That because in blockchain, the alert will go to every stakeholder, and without the consent of everyone, record cannot be changed. So this is. So friends, these were the few things on this problem and solution, which with my experience I can think of. And as I told you, that there can be many more, but unfortunately, that process is not being initiated. A lot of talk is there for changing whole hog, changing the system, but there's no talk on improving the existing system. So here I finish whatever I had to say, and then now we can you can ask question on this section or anything. Thanks.
Thank you very much, sir, for your presentation. It was a very enlightening talk for us and a very relevant one for us as planners. So I lost the connection in between. So some of the people had just some of the people had put in a few questions in the chat messages. I think Rashi, you had put up a question. Maybe you can ask it yourself. Rashi, if you are there, if you may ask put up
Yes,
your
ma'am.
question.
Yes, ma'am.
Yes.
Hello,
please.
sir. Very enlightening section. Am I audible?
Yes,
Yeah.
please.
Yeah, very enlightening session. Sir, I had a few queries regarding this land digitization aspect. Sir, in urban areas, since the land values are so high, so in some areas, land consolidation has not taken place. So, sir, since land consolidation has not taken place, so digitization has not taken place. Thus, that is causing a hindrance to mutations. Or online.
No. These are all okay. You complete the question.
Yeah.
Yes,
no, when it was a rural land consolidation takes place in rural lands only. But when it became urban, so the land values were very high. So these areas were not digitized. So what is your take in that, sir? First question
I tell you.
Yeah.
First thing is that consolidation is totally independent operation, unrelated to this.
Yes.
Consolidation, their consolidation was thought of so that more efficiency in agriculture.
Yes,
so
sir.
if people have separate plots at many places, then they can be combined. So there are merits of consolidation, there are demerits of the consolidation. Some people, some states have actually religiously done consolidation. Some states have totally abandoned it, like Himachal Pradesh.
Yes, sir.
So it is unrelated to maintenance of the record, keeping the record, or digitization.
Okay.
Your question, actually what is happening is that not the consolidation. Basically, urban records have not been updated.
Yes, sir, that is the main issue.
That is the issue.
Records.
Urban records have not been updated, and they are the issues. There are reasons for this is first thing is that once that area became urban, then number of transactions increased, plot size decreased.
Yes, sir.
The revenue authorities, they were not capable of handling this kind of job.
Okay.
Those Patwari and Kanun goes.
Yes, sir.
So for urban area, separate authorities should have been created for managing urban cadastre.
Yes, sir.
Which has not been done.
Okay.
Now it is assumed in urban area, many people have this misgiving that you get your mutation done in municipal record. In municipal record, only tax lists are there. So they mention your name there. But that does not have presumption of truth. So basically in urban area, land records or record of rights are not existing. Some states have taken, like Karnataka, they have done urban survey, they have done it. Maharashtra, they are in progress. So they are realizing they are progressing towards this. The issue is that urban cadastre have not been made.
Yes. Okay, sir. Thank you so much.
And
Okay,
another issue, interestingly,
Yeah.
another issue about urban digitization is that at least it is not clear who will take up this issue. At one point of time, the Department of Land Resources said that our jurisdiction is only rural area, because
Yes,
that is part of Ministry of Rural Development. And Urban Development Ministry says that that is not our job. If the states want to do it, then they can do it. So the computerization of urban land record, actually no one is owning,
yes, sir.
because it is difficult also. It will require a lot of money also. It will require a lot of business process re-engineering also.
And people are not willing to do it since land values are very high, so they don't want to.
No, why not want to? There is no problem. Like, land value is not related to digitization. It will make the system more efficient. People have initial distrust on the authorities. They think if something is being done, maybe that, we may not be affected. But that is not related. It is not related to land value. Rather, it because of high land value, it should be done at the priority.
Thank you, sir. Thank you so much.
Okay. I think another student had a question. Arun, you had a question which I don't recall what you had written in the chat box. You can put it up.
Good morning, sir. It was regarding the data which is regarding the land parcels should be is available to everyone or not. So I got the answer in later slides. It is available to each and every person.
Each and every person, but it depends on the state too. So you have to go to the website of the state and see whether it is available to you. Okay.
Yes, sir.
Okay. And I had a question. Before I ask my question, any other student, if you have, or faculty, if you have any questions, you can ask it.
Ma'am, again a question.
Yeah.
Yeah, sir, the government has drafted a land titling act recently. So your take on that? I mean,
I'll tell you. So let me tell you everything about it. As I told you, in government policy, Department of Land Resources, policy of 2008, this is one of the policies of the government to implement guaranteed title, which is actually title registration in India. Now the legal opinion is that these acts have to be brought by the state government. So the state acts have to be enacted by the state government. So the government of India has made, I think, 2 drafts of the one in 2011, and then I think another draft in 2013. 2013 draft I have seen. After that I have not seen any draft. So they have given a draft circulated to the state. Now the states have not taken interest, and not taken interest, the government of India would always say that states have not taken interest. But I interpret it in another way. Because states have to implement it, they know the ground position and they know how difficult it is to implement this kind of act. So that's why the states are not going for it. Rajasthan government tried twice. I think in 2008 or 9, they brought an ordinance which was not converted into act by the change of the government. Then again in 2016, they have enacted that. But recently I talked to the secretary there. He said, it has not been implemented. Because the real problems are in the implementation. Then, then the government of India had at one point of time, they thought that we will implement for some UT, so that at least there is a model. So I have tried to find out. If you search internet, you will find Chandigarh, for Chandigarh also, but nowhere it has been implemented. I could see only Lakshadweep, where they have given a public notice asking for comments on this. So at the present position is that it has not been implemented. In my book, I have in detail I have discussed what are the issues, what are the problems, and what has been the experience of other countries who implemented title registration.
Thank you so much, sir.
Yes? Have we lost the connection?
I think Chidambra's connection has gone. Maybe she'll resume in 1 or 2 minutes.
Okay.
So any other student have any question to sir? Yeah.
Sir, I'll again interrupt if ma'am has not joined. So just a simple
Okay.
question. Sir, your take on blockchains. Can it be easily implemented, or can it be the technology for future?
No, actually, this thing blockchain is a totally new technology. I do not know much about it. I will, I am trying to know. So, frankly speaking, but there is a talk about it. There is a talk about it, and then I have been told in Telangana some paper has been written on this that it can be done, but it has not been done anyway. This I know.
Yes,
But there
in
is a lot of
Sweden it
talk
has been
about it.
implemented.
No, it has not been implemented.
In
Where?
Sweden, sir. So Sweden
Maybe,
it has.
maybe.
Yeah.
Maybe. But again, I will tell you that still through blockchain we are improving the tool,
Yes, sir.
and we are not improving our old master, the law. So much is to be done towards the law, and we keep on improving our tools. Then effects will not come. So you will not be using full potential of any technology unless you improve your basic system. So both have to go simultaneously.
Okay, sir. Okay, sir. Thank you so much.
There is a, I think, webinar tomorrow. Some webinar someone has organized on this blockchain technology in registration. So I propose to join it. So let me see whether I can know
Okay.
more about it.
Okay, sir. Thank you so much, sir.
Okay, thank you.
Okay, sir, thank you so much for your lecture. It was a very, very nice talk, and as I mentioned, this was very relevant for our bee planning students. It's one full module almost you covered in such a short time. Something that we can even only think of doing it in 4 or 5 lectures. But I think it was so clear whatever you presented, and we already have a copy of your presentation, so it will be useful for our students. And thank you everyone for joining in. And yes, so students, you can leave, and I hope I again got disconnected for a while because of our failure here. So I hope everyone has had a chance to put up their queries and get a satisfactory answer from it. Okay, sir. So
Okay,
much
okay. Now,
for the
let me say that it has been very, very good experience for me. That to discuss with
yes,
all
sir.
you people, and it was such a good audience because you were asking questions. So that's why I am a little sure that at least my some of my things have been communicated. So anytime if any queries further any query is there, so I will be very happy. One can send through professor can send to me by email, or you can ask on phone, or anytime if you feel that on some point some more interaction is required, I am ready for that. Thank you very much.
Oh, that is very kind of you, sir. Thank you so much.
Thank you. Okay. So,
Okay, everyone. Thank you.
Thank you, ma'am.
Thank you, Sudesh. Is Ishita still here? Ishita?
Yes, ma'am.
Acha, I was recording the lecture. How do you stop recording and then get the
Ma'am,
recording?
you see the three dots there beside present now.
Just
You can
beside
just,
present now.
the three
Just
dots, and you just click
now
on
I'm
it.
on my I am on my mobile now. I'm not on
Okay.
the
Do you want me to stop it
laptop.
for you?
That will be great. Yeah. Can you do
I'll
that?
just stop it.